earliest in this broadcast, we talked about how a business separation, disentanglement, is similar to a divorce. The best time to plan for a divorce is when you're still in love. And many people who have suffered through a divorce recognize that the second time or perhaps the third time, they want a prenuptial agreement. Well, the business equivalent of a prenuptial agreement is a buy-sell agreement. And that's something that can be negotiated when the parties are still happy with each other, when they're thinking about what is going to be the future of the business, when they're looking for an exit strategy. A buy-sell agreement is an agreement that the parties reach voluntarily. Now, voluntary and voluntary is not always
voluntaries, yeah.
not always so voluntary. So one of the things that happens is in the absence of a prearranged buy-sell agreement, a prearranged way to get out of the entanglement, is one will say to the other, if you don't stop this, I'm going to dissolve the company. I'm going to go to the sanction option. And the survivor wants to say, no, don't do that. Let's see how we work something out. So one of the benefits of having a statute like this, which is so, I'm going to call it punitive, is it gives an extortion value to the party that wants to get out.
Because nobody wants to pull the rug, right? I mean,
Nobody
the
wants
pain
to,
has got to be,
and everybody's willing to.
yeah, right.
And accordingly, that's why you want to negotiate a buy-sell agreement at such time as the parties are getting along just fine. They're thinking about the future. They're thinking about exit strategies. They're thinking about the what if. Now, buy-sell agreements come in all flavors, shapes, and sizes. Oftentimes, they provide for what happens if one of the parties dies, so that the surviving party doesn't have to either dissolve the business or figure out how to get rid of a surviving family member that they don't want to be in business with. That's fine. Sometimes, less often, they deal with things like disability or retirement. What happens if one of the co-owners gets sick? Now, that's a two-edged sword because the co-owner who gets sick is normally also somebody who's been working in the business.
Still
and
need
therefore
the income, and yeah, sure.
They need the income, and by the same token, they're important to the business. So one of the things that has to be contemplated is whether the business needs insurance to cover for the interim costs of replacing the deceased or disabled co-owner. But Michael, the part that's most commonly overlooked in fairly well-drafted buy-sell agreements is what happens if the parties just don't want to be together anymore. They don't have a provision in them, oftentimes, for how to just disentangle a situation that's no longer working. In the buy-sell agreements that we draft and we recommend, you'll see that there are all kinds of provisions for that. I mean, sometimes we do what's called a put and a call. A put means that if somebody wants out, they can say, all right, I want out and you buy me out. A call is, I've had it with you, I'm buying your interest. The important thing on that is that there be a formula, that there be a recognized way for them to disentangle financially. Because in the absence of a recognized way to disentangle, one or the other will basically say, no, I'm not going to do that. And unless there are triggers in the buy-sell agreement to force those types of situations, then the buy-sell agreement won't be efficacious. Now, it's important to note that buy-sell agreements are contracts. And contracts sometimes are subject to interpretation. There have been cases where the buy-sell agreements have been either so outdated or so egregious that the courts won't approve them. Accordingly, what we recommend to clients who are contemplating a buy-sell agreement is that there be some type of flexible formula for determining the price. That flexible formula could be an appraisal. That flexible formula could be some type of relationship to book value with some adjustment for appreciated. I mean, these are not, 3-page documents that you pull off LegalZoom. Although, if you want to pull it off LegalZoom, that's great. We will certainly assist you in fixing that. But the thing that's important is that you contemplate how this is all going to work at a time when you're not angry. The worst time to negotiate is when the parties are angry or under duress.
And that seems to be perhaps more frequent than what we'd like to think.
It's not that it's more frequent than what you like to think. It's just the default. The default is, let's be angry. The default is, let's dissolve the company. And if we don't dissolve the company, then I want an extortion value. And again, divorce does not create money. Dissolution does not create value normally.
In your experience, Sam, are individuals who have been once burned, twice shy on these kinds of things, and do they then insist on some type of a buy-sell agreement?
Sometimes they do, and sometimes they don't. Oftentimes, when someone's been in a co-ownership situation that goes really south, they basically say to themselves, I will no longer ever have another partner. And therefore, they don't need a buy-sell agreement. On the other hand, many people who are not airline pilots get to learn from their mistakes. And they can then redo the second time, the third time, with some consideration for what's going to happen in the back end.
I think one of the things you said that really explains this so well, and you used the idea of a prenuptial agreement. You know, those are relatively common for individuals who have been through it before, and it lays down in very certain terms what goes and what stays, and who gets what. It would make sense, I would think, that the same would be true for a business.
That's correct. However, I will also tell you that I've had a situation where two people came in, they were forming a business, and I was talking to them a little bit about buy-sell agreements. And honest to goodness, these two people started to fight.
Right
and
there?
They started to argue over what was to be in the agreement and how much they were going to get. And you don't want to split up a pie that doesn't exist yet. You don't want to plan for a problem. On the other hand, it was a wonderful example of why they shouldn't be in business together, and they ultimately did not open
That was my next question. Did they go into business together? No, not so much. That's what happens sometimes when you get in the conference room and you have the conversation. Sam, thank you so much.